of offense, which is now prescribed as a Class D offense. New offenses that has been added to the subclause is that of a trafficable quantity of immature cannabis plants, which is a Class C offense, and a commercial quantity of immature cannabis plants, which is a Class A offense. And the main aim thereof is to soften the harsh penalties that may be imposed in terms of this bill. That there is certain consequential amendments that still needs to be effected to this clause, and that deals with the exchange of flowering cannabis plants and the possession in a public place of a flowering cannabis plant, and they also which also requires certain amendments to Schedule 4 to the bill. That will be presented at a later stage to the committee. I'll finish with this clause. Next clause is cannabis offences. That is in clause 4 of the bill. The clause mainly remains the same. The only amendment that is affected thereto is in respect of subclause 3, which removes paragraph A from the clause that provides for offense if a person fails to store cannabis in a secure place inaccessible to a child. In the response to comments that were received, it was proposed that the storing of cannabis in a secure place inaccessible to a child should be regulated by regulation, and the amendment mainly gives effect to that comment. I'll finish with this clause. Can I proceed?
Proceed.
Clause 5 deals with smoking and consumption offences. Subclause 1 criminalizes the smoking or consumption of cannabis in a public place. There were comments to the effect that we need to specify the minimum quantity of THC that a cannabis product must contain, and it's my submission that the amended definition of cannabis caters for this. So it's probably not necessary to specify the consumption of cannabis products in excess of a certain amount of THC. That's the only amendment to this clause. If there's no comment, I'll proceed to the next provision. Clause 6 deals with offences involving a child. During the public consultation process, or rather when we presented the comment and responses to the committee, a question was raised on the effect of cannabis on pregnant women and the unborn child. And we were requested to submit certain research in this regard to the committee. The department made the internet search, and obviously there were available articles in this regard. I can, amongst others, refer to marijuana use in pregnancy, and that is by Drs. Rebecca Thompson, Catherine de Jong, and Jamil Lowe. But the conclusion that was reached by the learned authors is to the effect that the research is currently incomplete, and it's not, they didn't make a scientific evaluation of the effects of cannabis on pregnant women or the child, unborn child. There's also the article named Cannabis Used During Pregnancy and Psychiatric Disorders. That was conducted, amongst others, by Carlos Ronquero. Again, the finding was that there's not available information in this regard, but they did indicate that cannabis may have some effects on a child or a fetus, and the effects is mainly symptoms of ADHD. But again, I must indicate that the research is rather inconclusive. There is also certain information that was obtained that, amongst others, indicate that it may affect folic acid uptake, cellular growth, and the neural development of a fetus. But again, this is not based on verifiable scientific information. Most other information that we viewed indicate that the consumption of cannabis during pregnancy may have the same results as that of alcohol and or tobacco if used by a pregnant woman. So I can provide the information that was obtained, but I did indicate that the final finding is that it is inconclusive and further research need to be undertaken in this regard. Regarding the offences under...
Before you proceed, Mr. Robert said there's a hand, Honorable Nibo Trachans and Honorable Steve Swart, in that order.
Thank you very much, Chair, and good morning to everyone, and good morning to Mr. Robert, sir. I just want to know, the research that you have found, which is inconclusive, where is it from? Which countries is it from? Because I would like to know that if any of the researchers did any of the research in South Africa. So if you could just indicate where the researchers were, where it's from. Thank you.
Thank you very much, Honorable Swart.
Thank you, Chair. I hope you can hear me clearer. I've changed my device, but I do also want to ask about the research. We know the Department of Health issued, when they made a presentation, they highlighted pregnancy as one of the concerns with the usage of cannabis. So I would ask you also to consult the Department of Health. And when you say that it seems to be the same as alcohol and tobacco, we are all aware of the fetal alcohol abuse syndrome. So I think that when you say it's inconclusive, I think we need to be very cautious when we are dealing with this issue. And similar to the other requests, I think we need more research done, and I would like a further consultation with the Department of Health on this issue. Thank you.
Thank you. Mr. Robertson.
Thank you, Mr. Chairperson. The information or the articles that I refer to is mainly from foreign jurisdictions. There is available, or some of the information mainly relates to the United States. No current research could be obtained that specifically relates to South Africa in this regard. The big problem is, as indicated in the various articles to which I refer to, is to the extent that cannabis has only recently been legalized in that countries, and no specific scientific research work conducted in this regard. And yes, we will consult further with the Department of Health regarding this aspect. Thank you.
Thank you. Any further hands on this matter before we proceed? You can proceed, Mr. Robertson.
Thank you, Mr. Chairperson. The next amendment relates to paragraph B of subclause 1. And the main aim is to substitute the expression possess with cultivate. I think in the context of the clause, it should be cultivate, namely that the child may assist with the cultivation of cannabis plants, which a guardian or child may lawfully cultivate. If we say possess, it may also refer to unlawful cultivation for person, or rather, let's just say unlawful cultivation, amongst others in a private place. So if we say lawfully cultivate, it addresses any concerns that or interpretational problems in this regard. The next clause that is discussed relates to the penalties that may be imposed, and that's clause 7. The first amendment is a correction that is effect to that clause. In the printed bill, it still refers to subclause 1, and there's only one clause. The option that is proposed is to lower the sentences which may be imposed, and that is in response to the comment and responses which indicate that the conduct in respect of which penalties may be imposed is extremely harsh. So the option proposed lowers the penalty for the Class A offence from 15 years to 10 years, Class B offence from 6 years to 5 years, the Class C offence from 4 years to 2 years, the Class D offence from 2 years to 12 months. And obviously a court may, in respect of all these classes of offences, decide not to impose imprisonment, but impose a fine, or a court can impose both such imprisonment and such fines. We were requested to meet with Justice Cameron regarding his view that imprisonment should not be imposed in respect of non-serious offences. I must admit the department has not consulted with Justice Cameron. But obviously, and I did indicate previously, insofar as it relates to addiction offences in any legislation, the department is in the process to finalize legislation which will actually ensure that imprisonment cannot be imposed in respect of a person that abuse any drug, and the type of conversion is proposed in terms of which the person should, under certain circumstances, be sent for rehabilitation in terms of applicable legislation. in terms of the South African law, in general, one of the principles of sentencing is that imprisonment should in most instances only be imposed as a last resort. And it has already been established that the seriousness of offense is one of the factors that can or should be taken into account when determining appropriate sentencing for a contravention in terms of legislation. And obviously, there are certain factors that needs to be taken into account to determine an appropriate sentence. And that's amongst others, and it includes the circumstances of the relevant person that was convicted of an offense, and also the perceptions of society, and also the seriousness of the offense, and to what extent the offense affects society as a whole. I don't think we've got a problem with that. The only problem is we did not consult with Justice Cameron. That was mainly due to the fact that I was unavailable for a certain period of time. Thank you.
Thank you. Any comments, members?
Swart, your chair.
Honorable Swart.
No, thank you. I think that the reduction in some of these sentences is to be supported. I would just like to ask whether restorative justice provisions would apply. We know that the Allen case for children, the court said it may not apply, but the NPA still has that inherent or jurisdiction to apply restorative justice. Could that also apply with some of the more minor offences? Yeah.
Did you hear that, Mr. Robertson? I was struggling to hear.
Mr. Chairperson, I heard something about the LM judgment, and the National Prosecuting Authority still support, and then I didn't hear anything else.
Sorry, the restorative justice processes, if possible.
Right. Thank you, Mr. Swart. Regarding the LM and 3 others judgment, the court found that Section 4B of the Drug and Drug Trafficking Act is unconstitutional to the extent that it creates, or rather is unconstitutional as a result of the Prince judgment, who excludes children from the read-in. And that's the basis on which Section 4B and the cannabis legal dispensation emanating from the Prince judgment
Mr. Robertson?
to minors. I did indicate previously during our discussions of the bill that various offences in the bill only pertain to an adult person and does not apply to any children. However, in respect of more serious offences, and especially the smoking or consumption offences, and the provisions of the bill still applies to children. Amendments to the Child Justice Act is affected in the schedule to the bill, to the effect that the offences in the bill that provides or criminalizes the conduct of any person, if it applies to a child, should further be dealt with in terms of the amendment to Schedule 1 of the Child Justice Act. And that's mainly the offences in Sections 3, 6, 7, and 9, 5, 7, and 5 of the Cannabis Bill, which is catered for in this provision. And that is inserted in Schedule 1 of the Child Justice Act. The effect thereof is that a child cannot be arrested, he cannot be incarcerated, and other measures to deal with the child other than incarceration will apply in respect of a child. Obviously, in respect of the more serious type of offenses like dealing in cannabis, it is still applicable to a child under the Child Justice Act. No amendments were further affected to the schedule, and the conduct specified in Schedules 2 and 3 of the Child Justice Act will then apply to the more serious offenses like dealing in cannabis. The LM judgment has not been certified yet by the Constitutional Court. We did prepare submissions in that regard, and it is submitted and is currently being dealt with by the Constitutional Justice in a regulatory environment. Restorative justice is difficult since it criminalized non-compliance with the standard in this regard that is set. And the standard aims to curate or restrict the access to cannabis or the harms that may be conducted in respect of another person through a contravention of the regulatory measures. My submission is that the bill cannot provide for restorative justice in this regard. And that is probably as far as I can take it. Thank you.
Thank you. Proceed.
Thank you, Mr. Chairperson. The next clause deals with the expungement of criminal records convicted of possession and use of cannabis offenses. During the submissions, there were proposals that we should consider persons that were convicted of dealing in cannabis on the basis of a presumption. The amendments to this clause mainly relates or try to deal with the expungement of conviction in dealing in cannabis under a presumption. I can refer the committee to, amongst others, Section 21 of the current, which, amongst others, as was pointed out by the commentator, containing a presumption that if a person possesses more than 115 grams of cannabis, it shall be deemed, or rather presumed, until the contrary is proved, that such an accused dealt in such dagga or drug. Section 21A1 is not the only presumption in a cannabis or in the Drugs Act that provides for a deemed provision of dealing in. I can refer, amongst others, to Section 21(1)(a)(3), although not relevant to dagga. It is to the same extent that there's a deemed of dealing in a drug. There's also Section 21(1)(b) and (c) of the Drug Trafficking Act that is relevant to cannabis, and that relates where cannabis is found on cultivated land or where there was conveyance of cannabis, the person on that land or the person that conveyed or was in such a vehicle that conveyed cannabis is presumed to have dealt in cannabis unless the contrary is proved by the accused. These provisions were declared unconstitutional by the Constitutional Court. In the discussion, I do refer to the cases in which it was dealt with. So there's probably a need to also cater for such offences. One of such offences, amongst others, relates to a drug where a person is within a specified place from a school. The amendments did require a renumbering of the clause. The current subclause 1 deals with the same aspects that is in the current printed bill. Clause 2, or rather subclause 2, deals with the exemption of or expungement of a criminal record in respect of a presumption, and that relates amongst others to the previous abuse of dependence producing substance and Rehabilitations Act and Drug and Drug Trafficking Act, and also similar legislation in self-governing territories before the Constitution took effect. It does not provide for automatic expungement of a criminal record. A person must apply to have his criminal record expunged. There is also a criteria that is prescribed on which basis expungement must be granted in this regard. And that is mainly to the effect that there must be indication that the person was in the circumstances convicted of dealing in cannabis on the basis of the unconstitutional presumption that is contained in the Drug and Drug Trafficking Act. And that is contained in paragraph B, and the remainder of the clause mainly relates, stays the same. We also do address a comment that was provided by a commentator to the effect that in the current or renumbered clause C, the word applicant should be substituted with a person. And we do give effect to that comment and response. Thank you.
Proceed.
Clause 9 deals with regulations to be issued in terms of this bill. Paragraph F is amended to, amongst others, provide for a renumbering or a reference to the current clauses in clause 8 after the amendment. That applies to paragraph F, G, and H. Another amendment to this clause relates to the self-medication proposal that was made, and it provides for regulations to prescribe the form and content of the certificate certifying that a person requires palliation or has a certain disease. Repeal amendment, the remainder of the amendments relates to the schedules of the Act, or of the bill rather. Going to deal with Schedule 3, and that relates to prescribed quantities. I did indicate previously that we're not going to allow sharing between adult persons of a flowering cannabis plant. So the first amendment relates to paragraph E of that schedule, which now prescribe the quantity or class of 2 immature cannabis plants that may be shared into, say, between adult persons. Also, with regard to paragraph G of Schedule 3, that relates to section 235. Amendment is proposed to the effect the no flowering cannabis plants may inter se be shared between adults and be restricted to 2 immature cannabis plants. Schedule 4 has been amended to, amongst others, provide for a higher quantity if we deal with commercial quantities. And the first amendment relates to the quantity that is required, or rather it's referred to in section 3.1c. And that is the cultivation in a private place of a commercial quantity of cannabis plants. It has been increased to 10 flowering cannabis plants. I know it was only 9, but we cannot make a substantial change in this regard, since it will amount to 20 non-flowering cannabis plants, but it is increased to 10 flowering cannabis plants. The commercial quantity, rather in respect of sorry, can I just in respect of 2, the amount is again extended to 20 flowering cannabis plants, or a cannabis plant equivalent, which amounts to 40 non-flowering cannabis plants. In respect of section 3.4b, that relates to the sharing between adults. The trafficable quantity of 6 immature cannabis plants is now prescribed. Again, no flowering cannabis plants can be exchanged. And so the commercial quantity is increased to 15 immature cannabis plants. Due to the fact that we exclude immature cannabis plants from this provision, they submitted that we can substantially increase the so-called trafficable quantity or commercial quantity in respect of non-flowering cannabis plants. So paragraphs A to D mainly provides for that. Paragraph E of that paragraph, or rather that's Schedule 4, relates to conduct that's prescribed in section 3.5b. And that relates to possession in a public place. Currently, it provides for 2 flowering cannabis plants or equivalent. It's increased to 6 immature cannabis plants. In relation to a commercial quantity, again, permitted amount of 15 immature cannabis plants is prescribed. In respect of section 3.6a(2) and 3, that deals amongst others with
Mr. Robertson? Mr. Robertson, are you still there? Committee Secretary, can you phone him?
hello?
Hello, Mr. Robertson?
Sorry, can you hear me, Mr. Chairperson?
Yes, we can hear you. We lost you for some time.
Sorry, that relates, okay, I'm currently at a new insertions as a result of the proposed clause 3.6, which regulates cultivation offences, and the amendments to 3.6 that were affected or proposed relates to the dealing in cannabis plants, and we do propose that a limitation in respect of a trafficable quantity of 6 immature cannabis plants be inserted here, and in respect of a commercial quantity, 15 immature cannabis plants. I must point out that any person who deals in a flowering cannabis plant is guilty of a Class A offence. That remains. Regarding the cannabis offences, there is no amendments to the schedule. I did indicate previously, in respect of medicinal use, we probably need, or rather the quantities still need to be inserted in the schedule to cater for that. And that will be done when the bill is submitted again after this to the committee. Schedule 5, there's no amendments there too. And I did discuss the amendment to the Child Justice Act. That to a large extent concludes the discussion of proposed options to the current bill. Previously, we were asked to address the committee on certain questions that were posed during the discussion of the comment and responses. The question will ask that we should clarify the expungement of criminal records of persons that was previously convicted of possession of cannabis, and it was asked whether there's a process currently in place to expunge criminal records for the use and possession of cannabis, pending the finalization of this bill. Obviously, there is provisions in the Criminal Procedure Act that do provide for expungement of a criminal record of a person. It provides that a 10-year period must expire, and then a person can make application that his criminal record be expunged. But currently, there's no other provision in any other law that could be used or can be used to expunge criminal records of persons that has been found guilty of an offence involving the use and possession of cannabis. The bill is an enabler to the expungement of criminal records. Question will raise, what would happen if a person is found in possession of cannabis during a roadblock? Obviously, the person, firstly, if it's possession in private, the offence of possession of cannabis in a place that is a public place and which is not concealed for public view will not apply. There's provisions in the bill that provide that if you transport cannabis, certain measures needs to be taken. It needs to be prescribed by regulation, amongst others that it must be stored in a certain container. But if a person is found in possession of cannabis while he's in a motor vehicle, he will probably commit that offense. And the transportation requirements relating to cannabis is mainly provided for in subsection 6. Another person that does not comply with requirements or standards of transportation is guilty of an offense. So if a person is found in possession of, let's say, 5 grams of cannabis in his pocket, he will commit an offense. There was reference to the open to THC level in hemp production. I did indicate previously that the bill currently leaves it open for other legislation to prescribe what the quantity should be in respect of hemp. I hope I did address everything else. Thank you.
Thank you, Mr. Robertson. And members, are there any comments after having had the whole presentation about the bill? The responses to the bill? Mr. Honorable Engelbach, followed by Honorable Swart. Honorable Engelbach.
Thank you, Mr. Chair. I apologize. I have no desire to take the deliberation backwards, but from my perspective, I think there might be a problem in terms of the definition of THC and CBD compounds contained in cannabis, because I think this bill might have a contradiction with existing law, and I do not see anything dealing with that in this particular bill. And the law of interest here is obviously the Medicines and Related Substance Act of 1965. So I don't want to go or belabor the point with details pertaining to THC and CBD, but I think that should this bill go forward and the relevant sections in the Medicines and Related Substances Act stay in place, there's obviously a conflict in law. So I don't know, shouldn't those particular sections be repealed before this bill takes into effect, or shouldn't this bill here deal with those specific contradictions in law and how to deal with them should and when these arise? Thank you, Mr. Chair.
Thank you very much, Honorable Engelbach. Honorable Swart.
Very briefly, I appreciate the hard work that's been gone into this so far. Obviously, from our perspective, we still have serious concerns, particularly as highlighted by the health department, that we don't think have been properly addressed yet. It is a concern, and we will engage further to try to improve the bill, but our concerns and objections are on record. So we look forward to further deliberations. Thank you, Chair.
Thank you very much. Any further hands? And Mr. Robertson, can you respond to Honorable Engelbach?
Thank you, Mr. Chairperson. I did refer previously to the amendments to Schedule 6 of the Medicines Act, which actually removed cannabis from Schedule, or rather THC, from Schedule 7 of the Medicines Act to Schedule 6, and to then specify what is included in Schedule 6 of that bill. The concern that we raised is probably in relation to the definition of a cannabis product. We indicate that cannabis product contains THC and CBD. But I must point out that the applicability thereof is already qualified by subclause 1(2), which specify that the provisions of this Act do not apply to any person who is permitted or authorized in terms of any other Act of Parliament to do whatever or cultivate cannabis plants. So from a commercial perspective, if we approach it from the perspective of the distribution of medical or medicines that contain those elements, this is already dealt with in terms of subclause 2. Other than that, one must remember that the Medicines Act has a limited application, and that Schedule 6 mainly relates to Section 22A, if I can remember correctly, of the Medicines Act, which amongst others provide that the person tried certain medicines into 10 regulates, rather can only possess medicine under, in terms of the Medicines Act, if he was issued with a prescription by a medical practitioner. My submission is that there is possibly not a conflict in this regard between the two pieces of legislation, unless it can be argued that a person may be prosecuted for offense to the extent that he is in possession of, let's say, CBD in excess of the quantity prescribed in the schedule to the Medicines Act, and that he therefore commit the offense as specified in the Medicines Act. Obviously, each and every law is subject to qualifications that is in other legislation. The Medicines Act relates to the distribution and prescription of medicine. And to the extent that it's not medicine, a person who possesses or rather possess cannabis or a CBD product in terms of this Act will not per se commit an offense in terms of the Medicines Act. So that is a possible manner in how it can be approached. But we will again consider the provisions of the Medicines Act in relation to the bill. One must also take into account that even in terms of the Medicines Act, Schedule 6, it already provides or excludes cannabis for private use that is possessed by adult person in terms of the Constitutional Court judgment. So that per se may create a conflict in that legislation itself. Thank you.
Thank you very much. Members, I would need your guidance. One, we had scheduled this briefing to last for 2 days, that is today and tomorrow. So we need to discuss, because I think we have done everything except the issue that we agreed that we will not deal with, that is the issue of the exemptions. But we have gone through the bill, all of it. So I would need to be guided as to what we should do tomorrow, because I think for now, Mr. Roberts is done. I think that is one issue. Secondly, my understanding of the discussion is that one, we are going to adopt this as a working document for our discussions on the 8th and 9th of March with the options that have been provided in the document. We're not adopting the bill, we're just adopting the document as our working document that will guide our discussions. That some work has already been put into this document. So we were going to take this document as our working document for the next few days when we deliberate as the committee. Now, can I firstly, do we agree that we adopt this as our working document to guide us for the purposes of deliberations?
Agree, Chair.
Thank you very much.
No problem.
Thank you very much. Secondly, that Mr. Roberts, you need to do further research on that issue of 18 and 21. Consult with the Department of Health, also consult with Judge Cameron, and ensure that by the 9th, in fact, by the 8th of March, you have already concluded your engagements with the Rastafarian community on the exemptions. Is that our understanding, members?
Yes, Chair.
Thank you very much. I think now, can I be guided for tomorrow? What should we do? Because we are done. I was going to suggest if members would be comfortable that tomorrow we don't proceed with the bill, because I think we are comfortably have comfortably covered the bill. That the research unit and the committee secretariat prepare that consolidated report of the oversight to both inland provinces and coastal provinces, that tomorrow we deal with the report. That is, they will present the report of the oversight and we process the report tomorrow. How is that, members?
Absolutely fine. Thank you.
Yes, if the reports are ready, yes, Chair.
Thank you. Yes, yes. And in fact, it's researchers, committee secretariat, are you ready with the reports? Bonani?
Yes, good day, Chair. Yes, the drafts are ready, Chairperson. We just need to consolidate them. We'll send them out, I think, later on today.
And then tomorrow people are going to do presentations. That's
yes, Chair. Yes, thank you.
No, thank you very much. Thank you very much, members. Thank you, Mr. Roberts, for the work that we have done. And continue doing the good work. We will meet you on the 8th of March.
Thank you, Mr. Chairperson. Just a question. The commercialization proposal, can I scrap it from the bill? If not, no, some guidance.
What about it?
I did indicate that enabling provision may be inserted in the bill to regulate this if there's no need to continue with this. And obviously I don't need to draft amendments to accommodate that.
I think it's a question that was raised by Honorable Horn. Can I suggest that we don't take it out for now. That maybe we discuss it further when we deliberate on the 8th. Then we can take it from there.
Thank you, Mr. Chairperson.
Is that in order, members?
I support that, Chair.
Thank you very much. Thank you very much, members, for your inputs. And thank you to everybody who is on the virtual platform and those who are watching us from home. Thank you very much to the department, Mr. Robertson, for the hard work. And thank you for the people who continue to enrich the process through their inputs. Let's meet on the 8th of March for the purposes of the bill, but the committee is proceeding tomorrow to deal with the oversight reports and other internal matters.
Chair, just my apologies. I'll be in the lockup for the budget tomorrow, so please note my apology. Thank you.
Okay, no, that's fine. Honorable Janji, tomorrow are you in the section 194, or you will be part of the meeting?
No, I'm here. We're doing it this afternoon.
Okay. No, thank you very much. Thank you very much, Honorable Janji. No, thank you very much, members. The meeting is adjourned.
Thank you.
Thank you. Recording stopped.